Tēnā koutou, and welcome to our first Leading Minds webinar for 2021. My name is Wayne Rumbles, project lead for the Technology and Legal Education or TeLENZ project funded by the New Zealand Law Foundation and hosted here in Piringa, Faculty of Law, University of Waikato. Today it's my pleasure to introduce this webinar on unauthorised posting of intimate recordings. We all live more and more of our lives online, and last year has only accelerated this trend for us to work, socialise, school and play online. Coupled with faster internet connections and the ubiquitous video technology we carry around with us, it is inevitable that intimate artefacts end up in a virtual environment. It is when these are distributed without authorization, whether to harm, humiliate, or to act or as an act of revenge, that we need to say through regulation that some behaviour is not okay, whether it's online or in the so-called real world. For many, the online environment creates social spaces that allow disinhibition to undertake behaviour that you either wouldn't be done offline or will be moderated by other social constraints. And unfortunately, for some of the online environment creates a space that offline abusive behaviour can be continued. It is for this reason that I welcome the introduction of the Harmful Digital Communications Unauthorised Posting of Intimate Video Recordings Amendment Bill that is the catalyst for today's webinar. I would like to introduce our three speakers. Our first speaker is Louisa Wall, Ngāti Tūwhare Taua, Ngāti Hini Uru me Waikato, MP and introducer of the Private Members Bill we are discussing here. And with two other bills currently before Parliament, she is a very busy woman. She is passionate about human rights and equality, which is reflected in her tireless work, especially for women's, girls, and LGBTQI rights. Our second speaker is Martin Cocker, who's been CEO of Netsafe since 2006. Netsafe is the approved agency under the Harmful Digital Communications Act. Martin works at the interface of community and the online tech industry, and therefore works with government and industry stakeholders to promote online safety to ensure that this environment is a place where everyone can enjoy without fear. He also represents Netsafe on Facebook's Global Advisory Board and Twitter's Trust and Safety Council. Our third speaker is a lecturer here at Te Piringa, Faculty of Law. She researches on topics at the intersection of criminal justice and legal policy and social cultural dynamics of gender and sexuality. Paulette currently teaches criminal law, evidence and cyber law, and I am lucky to co-teach with her on two of those papers, where I get to witness her passion and enthusiasm, which inspires our students to think about justice in a wider context. Without further ado, I'd like to hand over to Larissa to start our discussion.
Well, kia koutou and to Wayne, to acknowledge you and your leadership of TeLENZ, and Fleur, who work for your hospitality. I originally pulled from the ballot, thought your advice and support for the bill. So I want to highlight that. Can I also acknowledge Martin? He was one of the people I spoke to when the bill was also prepared to put it in the ballot, but also when it was pulled. So I look forward to the update he will share with us. And I'm looking forward to Paulette's work. We've had a brief introduction, and she particularly has voices of young people to share, which I think is incredibly important in this discussion about digital communications. So just a little bit about why I put the bill in the ballot and why this is an important topic for me. And I really do have to acknowledge two colleagues. The first is the Honourable Poto Williams, who's now our Minister for Police, who very passionate about sexual violence, family violence, and addressing issues in that space. And also the Honourable Claire Curran, who had worked on the bill and then essentially passed it over to me as something that I might be interested in looking at. And just for context, I actually submitted the bill in 2019, and it was around the International Day for the Elimination of Violence Against Women, which was the 25th of November. And there are as part of that global event every year, 16 days of activism. So as part of the cross-party women's group at Parliament, it was a commitment that I made to help end violence in all forms against women and girls. And then obviously last year in July, it was pulled from the ballot. I'm not sure if many of you know about our biscuit tin, which it literally is, but as a backbencher, you have an opportunity to submit bills. And for me, this was something I was passionate about. And as luck has it, it was pulled from the ballot. So essentially, what we're trying to do is to eliminate the unauthorised and non-consensual posting of intimate visual recordings, colloquially known as revenge porn. And from academics, McLean and Rackley, it was coined in 2017, this is actually a form of image-based sexual abuse. There was an intention, obviously, in the bill that harm could happen through these digital platforms. But unfortunately, the bill, as it was drafted, is just seeing the threshold too high. So just for all of our knowledge, currently, if you post an intimate visual recording or an image that hasn't been consented, the proof that is required for a prosecution is that you posted that image with the intention to harm or cause harm to the person. And then the second aspect of any prosecution is that you have to prove actual harm. And what this bill will do is take away that requirement, and essentially the law in the future will be, well, if it passes all stages through the Parliament, that posting of an intimate visual recording without the consent of the person is in and of itself harmful. And it really does focus on the issue of consent. Initially, the consent to create that image, to record that image. And then secondly, the consent of the purpose every time it is shared or every time it is posted. And I think fundamental to what we're moving toward is a very explicit regime that it has to be, consent must be in all circumstances informed and explicit. And we really are saying that in this space, I guess if you want to look at these images as a property right, then they reside with the person of whom the image is of. And so unless you have that person's explicit consent, then it will be in the future a criminal offence if you choose to post that. I could talk a lot longer, but I know we've only really got an hour for discussions. And a lot of what I said in terms of providing a context for this bill is in Hansard, and I talked about it through the first reading, and actually there were some very good contributions across the House. So this has cross-party support. But what I really want to highlight is our children, really, because we're talking about pornography and content, and the establishment of websites where these recordings are being posted on, and Martin will give us the up-to-date data. But, there are 3,000 sites where people upload these images to with the person's name, with their address, which obviously leads to further harassment, bullying, humiliation, etc., etc. And what I really want to have a conversation with is about when this bill should come into effect. At the moment, it comes into effect the day after it receives royal assent. But if people think there needs to be a delay to allow a lot more, I guess, conversation, education, so people understand the criminality of this behaviour, so that we can actually stop it happening and change people's behaviour before they get into the criminal justice system. I'm particularly interested in that, and also methods of engaging with our young people, so we give them the tools and they all understand, boys and girls, even though the majority of the victims from my reading are women, and it's a form of family and sexual violence. But I'm particularly interested in those aspects and whether or not there should be some additions to the bill And I know Wayne has talked to me already about the issue of deepfakes and synthetic media. And again, it's the same principle. If the person hasn't given consent, then obviously it's a criminal, criminal activity. So with those short words, and happy to answer questions later, I'll pass it back to Wayne, and looking forward to my fellow panelists' comments about this very important issue. Kia ora.
Kia ora. Thank you. So we'll have some Q&A at the end, but I think we'll give our speakers a chance to talk now. So we'll hand over to Martin.
Thank you. We'll pick up from there. I just start just by saying that Netsafe's purpose is to enable people to access digital opportunities and be free from harm. So, in a practical, to put it another way, Netsafe is here to protect people's rights to participate in a digital society. So that's how Netsafe sees the world. That's what we're trying to do. We're trying to make sure that everybody feels that they can safely participate in digital society. As Wayne mentioned, I've been at the helm of Netsafe for 15 years, so that does give me quite a historical view on some of these things, and I understand how they developed to get to the point we're at today. And as previously mentioned, Netsafe has a specific role governed by the Harmful Digital Communications Act, which is that we are something called, within the Act, called the approved agency, not a term we use publicly because it means nothing to most people. And it gives us three functions. One is to assist people directly, one is to provide public education, and the other is to build relationships with especially the international ICT industry to achieve those initial two purposes. I think it's worth, because we are talking about an amendment to the Harmful Digital Communications Act, I will sort of talk a little bit about the Act and where it's at, how we got to where we're at, and how it's going today. The Harmful Digital Communications Act emerged from a 2012 paper from the Law Commission called Ministerial Briefing Paper, Harmful Digital Communications, the Adequacy of Current Sanctions and Remedies. And it is actually an incredible piece of work and worth dragging out if you're ever interested in how some of these things came about. And they set out that eventually it led to the construction of this act, which its purpose was to, and this is, we'll refer back to this, so that's why I'm just chucking it out there. The purpose of the Harmful Digital Communications to deter, prevent and mitigate harm caused to individuals by digital communications, and to provide victims of harmful digital communications with a quick and efficient means of redress. And it's worth noting that the Harmful Digital Communications Act was, and a world first really, and certainly the civil part of it that looked for voluntary resolution before making something an offence, was really world leading at the time. So it's great to be a world leader, and New Zealand's often been considered a world leader in online safety, but obviously going first also brings some complications because you're also learning first. And just whilst I'm talking about the HDCA in a the Harmful Digital Communications Act, which I will continue to refer to as the HDCA, it is creating good outcomes. So just generally, the Act is doing what it was designed to do. 3,500 people come to Netsafe every year for direct support, has a very high rate of resolution, has a very high rate of customer satisfaction for that service. Hundreds of thousands of people access to public education, which is funded through the Act, through the approved agency. And New Zealand has some of the best relationships with international industry of any country in the world, leading to resolution for New Zealanders. But online safety does evolve very quickly, and we are increasingly seeing cases where the Harmful Digital Communications Act doesn't quite meet the needs of the situation the person is in. And so we have to look at options of amending the Act and amending other legislation and or developing entirely new legislation. So that's where we're at today. We're talking about a very specific amendment, and you know, this is the kind of thing that we are going to see a lot over the coming years as we work out how to make our regulation match the reality of our digital society. Just want to point out that quite a lot was packed into the Harmful Digital Communications Act when it was brought in 2015. You have the civil offence, the criminal offence, functions for a new agency, being the approved agency, a safe harbour for online content hosts. There was a new definition of intimate video recording, and there were amendments to other acts. It was a real packed act, and in terms of, there was a lot of stuff in it that was significantly changing the landscape in which we were operating. But just flag that we are looking here at section 22, which is the criminal section, where there is the fines up to $50,000 for an individual and 2 years in jail for an individual. There is another offence in the Act, and this is important, which is to breach a civil order. So when the civil process ends up with a judge and the judge makes an order, if you breach that, the offence of breaching that act is also, breaching that order is also in the Act, with a $5,000 fine and 6 months imprisonment. The HDCA overall has a 3-part test. So the content that is harmful must be aimed at an individual. That was to separate it from censorship regulation. It flows through, the individual is described as a natural person, and then it flows through to the term individual is used throughout to ensure that it is a natural person who is the target of the offence that is able to access the services. So that's the first test. It has to be a person, an individual. The second test is it has to breach a comms principle. So there are 10 communications principles. When we think of image-based sexual abuse, which we're talking about today, there isn't a communications principle which is image-based sexual abuse, but it is clearly contravening multiple principles, disclosing sensitive personal facts. They're often threatening, intimidating, or menacing, or wrapped up with threats. They're often used to harass an individual, which is another communications principle, and often published in breach of confidence because they were never meant to be public. And I've actually never heard anybody say that image-based sexual abuse is not covered by the communications principles, so I don't need to make an argument that it is. The third test is the harm test, and that's the one that we've heard already is a difficult test. Harm within the Act is serious emotional distress, which is a level just below mental injury. So you, as the target of this, of offensive content, need to prove that you have suffered or are likely to suffer harm, which is serious emotional distress, which is a pretty high threshold. And that was put in there because there was very significant concern at the time about the impact of the Act on free speech. And so the intention was to create a very high harm for people to crest. But so you've already got a high threshold in terms of harm. It is worth noting that within the civil process, it says that the court should not make an order unless it is satisfied there's been a threatened serious breach, or repeated breach of one or more of the communications principles, so basically evidence that something has happened. And then the second part says that the breach has caused or is likely to cause harm to an individual. So there has been a lot of focus on the difficulty of proving that you have been harmed, but there is already in there flexibility for a judge to review a case and say, despite the fact that the person is not presenting as harmed right now, the facts of the case make it reasonable to assume that they would suffer harm in the future. And certainly an unresolved and ongoing image-based sexual abuse case is something where you could easily make the argument that no matter how the person was coping with it today, some point in the future they would be likely to suffer harm, serious emotional distress. And so it is covered within the civil part of the Act. There is the flexibility within the civil part of the Act to find image-based sexual abuse cases as offences. We've heard about section 22 already. The key thing in there is that first part of the test, which is a person posts a digital communication with the intention that it cause harm to the victim. That's the difficult thing to prove because you're proving someone's intent. And we know that often when people post harmful communications, they say, I was joking. I thought it was insignificant. I did not think it would be harmful. And so for you to bring a successful prosecution under the current rules, you've got to overcome that position that people take. Not that long ago, it wasn't clear at all that image-based sexual abuse was an offence under New Zealand law, and there wasn't any real enthusiasm for making it one. In 2009, the Law Commission published a paper called Invasion of Privacy, Penalties and Remedies, and they considered whether it should be an offence. And at that point, they said, and very Law Commission words, they were inclined to think not. So that's 2009 publishing of images created with consent, but not consented to be published, didn't look like something that needed to be an offence. 3 years later, in 2012, they do the work for the Harmful Digital Communications Act. They reference their earlier work and say, look, we've seen what's going on, we've changed our mind, this should be an offence. And they did try to put controls for image-based sexual abuse into the Act. They recommended at the time that the Crimes Act also be updated. So the section of the Crimes Act, it's about 216-ish, has it has an intimate visual recording section, but it is entirely about recordings without consent. And they did recommend at the time that it be updated. It was not, and so all of the image-based sexual abuse controls laws ended up in the Harmful Digital Communications Act, which is clear in its definition that it is with or without consent in terms of the publishing. Sorry, it's captured with or without consent. So I've given that, it sounds all very rosy insofar as I've covered how the Act covers image-based sexual abuse. So the question then remains, why is it not getting everybody who is a victim of this positive resolutions? And the first answer to that is it doesn't get positive outcomes 100% of the time for any offence type. The complexities of online safety around jurisdiction, so people posting content outside of New Zealand or appearing to be from outside of New Zealand and outside of our legal jurisdiction, is a serious problem for us when we're trying to resolve these cases. The other is technology. It is easy to mask your identity. It is easy to hide. It is easy to be it makes it difficult to prove an individual is the person producing content. So between the jurisdiction issues and the technology issues, resolution of harmful digital communications is imperfect at the best of times. If you go back to the 2016 legislative process and look at the debates in Parliament and look at the Select Committee presentations, there was a lot of activity around the Act and a lot of concern around that it was going to suppress free speech, that it was going to criminalise young people. There was significant concerns about the construct of the safe harbour. And as a result of that, a lot of policy and regulators' time was spent on what we would now consider to be the wrong things. They were spending a lot of time reviewing those aspects of the Act and not a lot of time looking at where the Act rubbed up against other laws and or whether it was constructed in a way that could combat some of these more serious harms that we're seeing today. The civil process, which is the one that's most flexible in combating image-based sexual abuse and doesn't have those barriers that the criminal one has, is based on a mediation type process. So where parties are keen to come to a resolution, where both parties, as in the person who is the target and the person who produced the content, wish to find a resolution, the system works perfectly. Unfortunately, image-based sexual abuse is often tied up in abuse. And in those situations, one of the parties is not coming to the conversation in a way that is looking for resolution. They are aggressors, they are not interested in finding a resolution. And so our options are limited because if one of the parties is not interested in engaging constructively, then our options at our stage are limited. Then you progress to the district court. So the district court does not have the same limitations. It can make orders on people. It can compel people to do things. The problem is there's a big step from what Netsafe does and the agility of the Netsafe process and our ability to meet the quick and efficient process requirement to the district court. The district court is, with all my love for everybody who works at the district court, the district court. It is slow. It is not easy to access for a lot of people. If your opposition in the district court has access to a lot of resources, then it can be very difficult to win a case and successfully take a case. So originally, the Act called for a tribunal backing up the approved agency, not the district court. And the exact reason for that was the speed at which the tribunal could do things, the depth of understanding the tribunal would have for the specific cases that was bringing. And I do think, at the time, I did not oppose the idea of moving from the tribunal to the district court. I did not foresee all of the complexities that the district court has over the tribunal idea, which was originally proposed by the Law Commission. But over time, I have seen how difficult the gap between the approved agency and the district court is for victims of this kind of abuse. There is a misconception that Netsafe, just to clarify, there's a misconception that Netsafe decides who can progress to the district court. That is not the way the Act is written. You must come via Netsafe, but regardless of what the outcome is of the Netsafe process, you are allowed to go to court. Whether you feel we were successful or unsuccessful, you are allowed to go to court. The advantage of this is that it means that Netsafe is not forced to run processes with a very high threshold of proof. We don't have to do deep investigations to ensure that we always make the right decision about who can go and who can't go to court. The disadvantage of it is that it leads to a very disconnected process between Netsafe and the court. We don't have the ability, for example, to fast track something through into the next path because we believe a person is at risk. So just getting to a summary point, we do support the bill because we see what IBSA does to people's lives. We deal with between 15 and 20 cases of harmful digital communication a day. About 10 or 15% of that, so a couple of people a day, are reporting what is essentially image-based sexual abuse. So we're very, very aware of what the harm is. We're very aware of how difficult it is for people to get and seek to access justice on this. And so I think that the amendment certainly makes it easier for victims of IBSA to get a positive outcome. I also think that more generally, the Harmful Digital Communications Act would benefit, or combating harmful digital communications would benefit from the tribunal idea that was originally floated. And I also think that even the test within the existing Section 22 could be amended to remove the intention statement and replace it with an ordinary reasonable person statement. So an ordinary reasonable person would be aware that it would cause harm, one of those type of statements, rather than that intention statement. So I'll wrap my official bit there and throw back to you, Wayne.
Kia ora. Thank you, Martin. So we'll hand over to Paulette now and give her a chance to speak. And then I see there's a few questions coming in the chat. So people, please keep bringing them in, and or you can ask them directly at the end of Paulette's talk. So hand over to you, Paulette.
Thanks, Wayne, and tēnā koutou, katoa. To everyone, so that was quite a fulsome speech from Martin. So I'm just going to make a couple of short comments in relation to the proposed new criminal offence. Although kick off from what Martin said about Section 22. So under the proposed section, the definition as an intimate visual recording as captured in the Harmful Digital Communications Act is going to cover, I think, is going to allow action to be taken more easily in terms of certain types of material, but some types of material are still going to fall probably outside of Section 22A. And so I support his idea about making changes to Section 22 as well. Which will continue to be the test. This intention to harm test will continue to be the test for types of digital communication that don't fit the definition of intimate visual recording, even if the amendment is accepted and goes forward. So that idea of changing it from intention to harm to recklessly sending a digital communication that an ordinary reasonable person would have realised could cause harm would be an improvement. That's a good idea, Martin. So just going off from that comment I made about intimate visual recording, at the moment, it's a fairly thorough definition in that it captures things like taking photos or digitally capturing imagery of people who are un or partially dressed, who are engaging in sexual activity, who are engaging in personal hygiene. And it also includes surreptitiously taking intimate pictures of someone who is clothed, so upskirting or down blousing, as we call it, in circumstances where the person pictured would have a reasonable expectation of privacy. So it's going to cover, I think, a fairly wide selection of materials, kinds of materials that we think of as forming intimate image-based sexual abuse. And so, for instance, things like, and in particular, the misuses, the range of misuses that falls under that term of image-based sexual abuse, which is much wider than revenge pornography. So, for instance, it will include, hopefully, the use of images to exert coercive control in intimate relationships. What we think of as revenge porn, but Nicola Henry and Anastasia Powell have renamed as relationship retribution, which I think is perhaps a better term. And in the use of images, explicit images, to extort further images and to achieve compliance from people in a whole range of contexts, from domestic violence, but also into things like sex trafficking. But of course, intention doesn't cover, at the moment, because the test is based around intention, it's not very useful with the types of digital communications, which are really more focused around acts of sexual voyeurism, for instance, and when the posting is not used against the victim specifically, but as part of a kind of racist or misogynist practices, in which the audience is the aim is to incite the audience rather than the particular person in the image. So sometimes there can be a sexual motive for that, and sometimes there's not. There can be just a way to create chaos, to gain kudos amongst peers, to make money out of those images by selling them on to pornography sites and into the commercial trade in sexual images. And so those types of imagery, or the motivation, the misuse, in which the purpose is not necessarily to cause harm to the individual who's captured by the image, but for a whole bunch of other reasons, should now be caught under this amendment if it goes forward. As we've heard, I think it probably won't cover some things like what Claire McGlynn and Erica Rackley have called sexualised photoshopping, what we talk about as deep fakes, or the synthetic media kind of motion. I don't think that that's going to fall, in my reading at least, under what's meant by intimate visual recording at this point. So the change to section 22A, because it focuses on the act of sharing without consent rather than the intention behind the person, will shift both the test but also the scope, I think, of what is covered, the type of misuse that is covered. And so that's really great to see, because whilst revenge porn was the kind of media-friendly term that became very popular, we now know that image-based sexual abuse is a much broader behaviour than that. The other thing I wanted to comment on is around harm. I mean, one of the problems with the current section 22 is that not only does the Crown have to prove an intention to cause harm, which is quite a high standard to prove, but in fact, the complainant also has to, well, the Crown has to also demonstrate that the complainant has suffered harm, and that has been problematic too. So, because it puts a burden on a complainant to manifest harm in a particular kind of way, and you know, even my cyber law students pick up on this idea that that really feeds into the kinds of victim blaming or victim scrutiny that happens in sexual crimes trials, and is an unfair burden on them. And we can see that in particular in one of the cases that's been critiqued under section 22, where in the case of Aya, the defendant published pictures of an ex-wife on the internet and used it to exert power over her in relation to separation. And it was posted on a forum where members of her family, including possibly her children, would be able to see it. And the judge held that the communication could cause anxiety, stress, insecurity, and so forth to a person in that situation. So found that both the first part of the test and intention to cause harm was there. The second part of the test is actually that a reasonable person would have been caused harm in those circumstances. And the court said, yes, they thought that a reasonable ordinary person would have been harmed in those circumstances. But then the third part of the test, which is that it actually caused harm to the complainant, the judge held in that case that the complainant had not in fact manifested enough harm for conviction. She was only, in the words of the judge, frustrated, angry, anxious, very upset, crying, appeared very depressed, and required continual personal emotional support. The judge said that that was not sufficient. What was required was specific evidence as to the root cause of her need for support. One wonders what that might be, given what he had said had occurred, and also how exactly this woman failed to match up to being an ordinary, reasonable person, given what the court had said. So that's a second, aspect of the test I think is really problematic, and it's really pleasing to see that that won't be a part of Section 22A in the future, assuming that this gets passed. I do have some other comments to make about harm, but and in particular to draw attention to the increasing amount of research which tells us that the kinds of harms that manifest from non-consensual posting of explicit imagery is really significant. And there was some research last year of 75 victims from Australia, England and New Zealand talking about the harms. It makes for quite difficult reading, and one of the things that really struck me about it, reading it, was the ways in which they talked about the harms and the experiences that they were caused line up so much with the ways in which victims of sexual violence talk about sexual violation. So they talked about significant social ruptures to their lives, developing changing their behaviours, a change to their sense of self, a change to their sense of safety in the world, a lack of understanding about who might have seen the photo, and so social isolation, not wanting to go out in the world, but also digital isolation from not wanting to experience the kinds of online sexual harassment, the kinds of piling on behaviours that come from others who've seen the images, and the lack of sense of safety because sometimes people's names and addresses are attached to those images. So, we have an increasing understanding about how significant the harms can be and the degree to which these really mimic and in fact are sex crimes and need to be treated as such in particular cases. Just one last comment. Louisa mentioned about young people. So at one end of the scale, or on one part of the continuum, we have really serious harm, and then we have concerns about not over-criminalising young people's sexual practices. Also last year, published a paper was published, I was an author, so it was Nicola Gavey, who's here, I think, we talked with young people in Auckland High School, young women in an Auckland High School, about sending sexts, or what they called sending nudes, and the kinds of pressures that they felt to both participate and not participate in that. And I think that's a useful context. They felt both pressured through peer processes and through constant harassment to share their nude images. They were highly vigilant, constantly being asked and having to kind of constantly say no. But at the same time, wanting to participate in exploring their sexuality and developing sexual relationships, and trying to kind of constantly figure out, is this person genuine? Will my image be treated how I want it to be treated? In that really difficult space for them. So there is a need, I think, for more support and education for young people, as well as a change to the laws that we've currently got, which are too over-focused on intention and occurrence of harm. I'll leave my comments there, but congratulations, Louisa, for having this bill drawn, but also for getting ahead of the game and actually having something prepared and ready to go. I think it's an excellent piece of legislation. Thank you.
Kia ora, speakers. Sorry about that. We've had a few questions and comments through the chat. I think we'll go through those, and if we've got any time, there might be some comments from other people. So the first one is, what is the current situation in relation to automatic name suppression for a complaint of image-based sexual abuse? I'll open that to anyone who can
I don't know if I can answer that too expertly, but normal district court rules apply. So there isn't anything in the Harmful Digital Communications Act's, the specific rules about the Harmful Digital Communications Act that covers that. So it's normal district court rules.
Which is to say that there wouldn't be automatic name suppression.
Wouldn't be, yeah. That would be my understanding, yes.
The next question from Myra is around express consent. So she's asking whether the idea in the bill is that the accused would need to prove express consent for a particular posting, and if so, how could this be demonstrated to satisfy an express consent requirement?
Well, I mean, that's a really interesting point, because we want express, voluntary and informed, and usually you'd have to sign something, right? You'd have to have a proof that you'd given it rather than just verbally. That'll be one of the issues that will have to be discussed. I would have thought, I mean, if you shift it to another medium, anytime I've had to, well, we didn't actually give consent, I was going to say, to record this. Usually something pops up and as a panelist you agree to it being recorded so it can be shared in the future. But it's probably processes like that. I mean, you will have to prove that you do have consent. Maybe someone is, yeah, it's an interesting issue. Text exchanges, asking.
What if you decide later on that you don't want to consent?
Well, that's only for that one particular posting. I mean, yeah. What we're saying that every time you post it, you get consent. It's like, actually, every time you have sex with somebody, it should be consented. Every time. You know, they're discrete events, and you may agree to the image being recorded. That doesn't mean that you've agreed to anything else. And then any subsequent use of that image, it should be explicit express consent every single time.
So you mentioned there were like 3,000 sites that
yeah,
take these images.
That was from research that Martin and Netsafe did. Right. And apparently, you know, there's 100,000 New Zealanders that this has applied to, where their images have been posted without their consent. But Martin, is there an update on that report that you did?
I mean, the number of pornography sites that will allow the upload of images and is extraordinary, and the number of sites that will allow upload of pornographic images is extraordinary. There are thousands that are designated, I guess, pornography sites, which can be uploaded to. What Netsafe did recently is we organised an arrangement with MindGeek, who is the organisation behind Pornhub and a huge number of pornography sites, to establish a trusted flag arrangement where we could have images taken down if they were reported to us. MindGeek have just moved to a system where you can only upload content to their sites if you're accredited. So hopefully that'll reduce the number of sort of illegal uploads or uploads against the consent of the people in them. So the value of our trusted flagger status with them has probably been reduced. But unfortunately, there are just thousands more sites, and we know them all too well here, where people can upload, and they certainly have no interest in our jurisdiction or our view on whether something is legal or not. I just jump in and say on the consent thing, there are very few cases where people consent to their images being shared online. I mean, there are people who produce adult content for the purpose of making money from it, and they have an explicit consent arrangement, and that is, you know, typically documented and contracted, etc. But I mean, it's very difficult to think of occasions where somebody produces this kind of content and then would consent to it being made public. I mean, it's very unusual for people to have this level of personal content, and wish for it to become public. And I guess there's also, this happened a lot when we talked about the Harmful Digital Communications Act in the very early days. When you pick it apart, it can be very difficult to say, well, how could you prove or disprove consent? But of course, it is intertwined with the harm concept as well. So you're proving, you're having to prove them all, I guess, or them together as a group, because of the way the Act's constructed. So you could have cases where the consent is not entirely clear, but there was something else within the Act that defined whether someone was happy to consider it an offence, was somebody considered an offence or not. But I mean, yeah, we don't, I mean, maybe it's my viewpoint, 15 years at Netsafe, but we don't, there aren't people who consent to this outside of, business arrangements.
I'm not so sure about that. I have been doing research with people in online sexual communities who do post pictures of themselves engaged in sexual activity with other people in those photos, and it's a form of sexual practice, I guess, and I think that I have some concerns about the criminalisation of those practices because they are primarily people from the LGBTIQ community. And, we do have a long history of legal regulation of queer sex. And, I think there is a need to be a little bit concerned about ensuring that people who want to engage in sexual practices that are outside the norm don't get caught up and been criminalised when they don't have the kinds of harmful intentions. So there is a tension there, I think, to some degree.
Are those usually a subscription-based kind of system where the subscription itself is kind of like a form of consent, that you're part of a community and it stays within that community normally?
Most of them are membership-based, but membership on internet websites is really just having an email address part. So no, I wouldn't say it was covered by that.
Yeah.
And I just wanted to add, so submissions are currently open on the bill, and so anybody can make suggestions for amendment. And, maybe we do need to define or outline what a consent process looks like, or to be really clear what it is outside of the scope of the bill. I mean, what you've just outlined, Paulette, I'm not wanting to criminalise that at all. I mean, the aspect that I've really focused on is the sexual violence, is the crime issues, because it is a form of, exploitation of women and girls and others, I have to add. But if there are any amendments to the bill, there's an opportunity for anybody to make those proposals to the Select Committee, and then we'll see the collection of those proposals and how the subcommittee responds to all that input. So there's lots of scope to add value to the bill as it's currently drafted.
Yes, and that's a constant tension of the criminal law, isn't it? It's trying to define the thing that you want to prevent or stop, and without capturing other things. Yeah.
Actually, this is probably a question for Martin, whether we've really exhausted researching sort of options to strengthen individual rights. I think, Louise, you mentioned that an image should be regarded as a personal property, and in terms you use the word ownership, and I'm kind of in favour of personal information generally being regarded as one's own, and having more rights about that, how it's shared. So I'm sort of thinking, before we launch into yet another criminalisation session, are there ways that we can actually strengthen, if it happens to me, I can ring whatever site and say, I didn't consent to that, this is me, take it down please. Why can't we do that? What's standing in our way? And I know there's a lot there, but I'd like to hear it.
Reality, I guess. If those were New Zealand-based sites and within our jurisdiction, or even if there was some, international cooperation that led to a much larger percentage of the internet, adhering to our legal requests, then some of those approaches would be a lot more successful. The reality is it's pretty easy to get content and put it somewhere which is outside of our jurisdiction, and so we have to find something that is within our jurisdiction, and that is the offender. And so that's why that's how we're sort of constructing our responses at the moment. I mean, you're sort of lifting the lid on a whole fascinating conversation about changing our view on how we go about keeping people safe, and the strain that it's placing on a sort of traditional regulatory response. But like I say, once you lift the lid on that, it's a long conversation and a lot of work.
I mean, I suppose when it comes down to it, are we still at that? I'm sort of looking at that other bill, the one for the classification office, where they want more powers to take down content, but also potentially use filtering as a way of either removing our access to it or encouraging the large sort of global techs to adopt certain policies with our country. Other countries, say when you look at Google or Facebook, may have had to alter their policies around moderation of content or what sort of content is visible to a particular population. So I'm sort of looking at what's happening with both these proposed bills, thinking, well, is it an opportunity to change our thinking of it and shift kind of the emphasis of our human rights to what happens to information about us?
Yeah, and I think the quick answer to that is we actually need both. As I mentioned, 2 or 3 people will call Netsafe today who are victims of image-based sexual abuse. So we need to find responses soon, because some of those people will not get supported by the system today. So we something that is robust enough and effective enough to help those people without doing any unintended harm. I think we've got to look at those. If we had another incident like we had on March the 15th, 2019, we want to be in a better position as a country to combat it, and so we've got to put those controls in place. But there is definitely a longer-term, strategic, rights-based, kind of total rethink about how we approach certain challenges that we face now that we have a digital society that we need to do as well. So, I wouldn't want to say that these kind of regulatory responses are all of the solution, but we need them because these problems exist right now. That's my answer.
Can I just ask Martin, when is there a review scheduled of the overall Act? And when's that going to take place?
Sorry
you could treat this bill as a way to put all the other issues on the table. I mean, that's your
Yeah, we are likely to in our submission.
Yeah.
And just throw in a few other things that could be sort of picked up with it. The Harmful Digital Communications Act had a 2-year review built into its when it was brought in. There was a 2-year review brought in. There was a review undertaken. I know people have said we demand to have the review. The review was actually undertaken. It was undertaken by the Ministry of Justice, but it was mostly just to check that the bill was, that the systems were working. It wasn't a broader view of whether there was other things we could do to combat harmful digital communications. So there's no further scheduled review. And you're right, an amendment like this then creates an opportunity to have that wider conversation.
There's a couple more questions. We've got a few more minutes. Myra's asking whether the proposed penalty in section 22A is strong enough, given that it's similar to section 22, and where the courts are not sentencing near the top of the penalty band, so she's making an argument, is it strong enough for a substantially more serious crime?
Well, I think this will be debated quite heavily. I think that will be arguments in the opposite direction too, that it is too strong. I think I saw some mentions around that in the Hansard. It is closer to the Crimes Act sentence that's provided in the intimate visual recording in Crimes Act is for 3 years, so it brings it equal to that. I do wonder whether, sentencing is a point at which you can differentiate between those who do something wrong and those who do something wrong with a great deal of malice. And there can be, that's not uncommon in the Crimes Act. If you do something, you do it this way, you get a sentence that's much higher than if you do it this way. That might be a potential if we can establish really significant harm being done, that does suggest a need for a greater penalty as a form of prevention.
So we've got one last question from Peter here. He's considering if someone gives consent for an upload of an image and then they decide to remove that consent, does that original image that has been uploaded need to be removed? And if so, it's not always possible for the person who uploaded it to remove it from a site. So how would that work, he's asking?
Well, that's a really good question, because there's no criminality in that. It seems to me it becomes a logistical issue about how you take it down. It's not, so if the person consented and then changed their mind, like any ethical principle, it's the person's right to change their mind at any time. But it would be, what is the mechanism if they say they can't get it down? Martin, can you help there? Or, I mean, that's...
Yeah, like I picked, there's a thing in the concept in the Privacy Act, isn't there, about you having a responsibility for maintaining data in a way that you can control. So I guess, you could take that kind of view and say, if you do post it, you've got to have control over it. I mean, the reality of the internet is it's not very likely. People can take images of it and share it elsewhere. So there is that option, but yeah, I mean, you'd be talking about a small number of cases, I guess, although there will be people who change their mind later in life. But yeah, I don't have an answer to that. That is a ongoing problem of the internet, that people do something one day and it stays on the internet for all time, and they may change their mind later about whether they would have chosen to do that, but that option's not available to them.
That raises the question of corporate ownership of your images. Like Instagram policies, where they basically take images and must have the most enormous file in the world.
Well, as a safety advisory board member for Facebook, who owns Instagram, I can say that is a legal requirement so that they can share images with other people. But unfortunately, it's an all or nothing. Either you give them that right and they can do whatever they like with it, or you give them no rights and then you can't access the service. So that's one of those things where you need a whole kind of construct change to get the actual outcome that users want. But the current options are these two polar extremes. Either the service doesn't work, or you give them total access to your information and your images. So we often use commercial law and copyright law and things like that to combat some of these social issues, because it's there and it's an option. And some of the most developed systems on the planet for removing content are being developed purely around enforcing copyright law. So where possible, we use those to get people's content removed from sites. So there is some, if you can find a commercial aspect to it, or a copyright element to it, you often can get a positive resolution for people.
I think we're just about out of time. So I'd just like to thank our speakers, Louisa, Martin and Paulette. And having been the father of 16-year-old twins, this is an area where I have to navigate in somewhat personal terms, particularly having a girl and a boy twin, and recognising actually the social pressure for sharing content online within a school environment. So this has been fascinating, and I'm sure, and from the content in the chat, I'm sure all our participants have enjoyed that as well. So thank you to all of you, and kia ora koutou.
Kia ora. Thank you.
Well, thank you.